Is Texas a community property state? Texas is indeed a community property state, a designation that profoundly affects the division of assets and debts in marriage and divorce. This system, based on the principle of shared ownership, treats most assets and liabilities acquired during the marriage as jointly owned by both spouses. This approach ensures fairness by recognizing the contributions of both parties, whether financial or otherwise. However, community property laws can also complicate matters during a divorce, requiring a clear understanding of how property and liabilities are classified and divided. Legal professionals play a critical role in navigating these issues, particularly in complex cases involving substantial assets, disputes over property classification, or business interests. How Texas community property laws work. The community property framework in Texas is rooted in the Texas Family Code and the Texas Constitution. These laws establish that all property acquired during the marriage is presumed to be jointly owned, with specific exceptions. For instance, under Texas Family Code Section 3.003, property is classified as community property unless a spouse can prove otherwise with clear evidence. This classification includes earnings, real estate, retirement contributions, and personal property acquired during the marriage. Even items titled in one spouse's name may still be considered community property. Conversely, assets owned prior to the marriage, inheritances, gifts, and personal injury settlements are classified as separate property, provided they are not commingled with community assets. For debts, the rules are equally comprehensive. Community property laws hold both spouses responsible for debts incurred during the marriage, such as loans, credit card balances, or medical bills, even if only one spouse initiated them. What is community property in Texas? Community property encompasses a broad range of assets and earnings acquired during the marriage, income and wages. Earnings during the marriage, regardless of which spouse earned them, are community property. Real and personal property, homes, vehicles, and household items acquired after marriage are jointly owned. Investments and retirement accounts. Contributions made to financial accounts or retirement plans during the marriage are community property. Business and rental income. Revenue from businesses or properties managed during the marriage is shared, even if one spouse runs the business or property. Despite this broad presumption, certain types of property, like pre-marriage assets or inheritances, are protected as separate property unless they are mixed with community assets. When disputes arise, courts often use financial tracing to establish ownership. Managing community property in divorce. During a divorce, Texas courts aim for a just and right division of community property. While this doesn't necessarily mean a 50-50 split, factors such as earning potential, the nature of the assets, and each spouse's financial needs influence the final decision. Courts also address the division of community debts, allocating them equitably while considering the specific circumstances of each spouse. Understanding Texas's community property laws is vital for protecting your rights and interests during marriage and divorce. Working with an attorney can help you clarify the classification of your assets, address debt concerns, and pursue equitable outcomes in property division disputes. Lawyers ensure that your unique circumstances are considered, while law firms provide the legal resources needed to navigate these challenges effectively. For personalized legal assistance in San Antonio, contact Family Matters Law Firm PLLC. Call 210-997-2914 or visit our office at 926 Chulie Drive, San Antonio, Texas, 78216, to schedule a consultation today. Protect your financial future with trusted guidance and experienced representation.